everybody. So it's actually a Friday. This is a pop-up, but it's also my ninth episode. And I had to jump into this whole conversation about President Trump, the Supreme Court. What does it all mean? This is a really informationally packed show. So hit the record. Make sure you come back in case you missed something the first time. Follow me on social media, whether it's Instagram, X, YouTube, at I am Friday Jones. That's me, Friday Jones. I'm your host. So we're going to get into it. I'm going to run my little clock really quick. Share a little bit of reparations information for the reparations minute, just information you need to know.
We want the whole menu. We don't just want the appetizer. We don't just want the main course. I want some dessert too, maybe two desserts. And the instinct in movement work is to sequence, is to introduce a bill, to wait, to build support, to wait again, to ask for a hearing, to wait again. Maybe you'll get a vote, maybe you won't, maybe it'll die, right? That sequencing logic has kept HR 40 waiting for over 36 years to be voted on the House floor. What we did accomplish last week was refusing that kind of logic. We said we need these activities as a comprehensive runway to this fake celebration that America 250 is. We said we need a press conference because the masses need to know that this work is alive and well at the federal level. We said we need a congressional meeting because we need to have strategic inside work on how a full reparative justice agenda needs to be adopted by the Congressional Black Caucus.
All right, if you guys do not know who that is Dreesen Heath, and above her, that's a post by Dr. David Johns. If you're not following the two of them, you should follow them. They are part of what I call, that mainstream sort of tapped in legacy group of organizers around reparations. David Johns is an advocate for LGBTQ, but he remembers always that he is Black first. I have to shout him out. I have to shout out Dr. Marcus Anthony Hunter, who invited me, I want to say 2 Novembers ago, to the White House into this everybody who was anybody in terms of legacy reparations was in that room, but they were there with our legislators, with Cory Booker, with Cori Bush when she was still in office, with the brother from New York who left with Cori Bush, with some of the DNC sort of old guard, with Barbara Lee from my home state of California. And it was kind of like this whole powerhouse thing, and it was very unfortunate. As a lineage organizer, I was happy to be invited. What was hard for me was that I was the only lineage reparations advocate that was invited. And what Dreesen is talking about is very necessary in that there's no need for us to be waiting. This playing by their rules mentality has, as she said, kept us in this space my entire adult life. I graduated from high school in 1989. I know some of you all think I'm a little younger because that black don't crack. But despite my DNA and my gene pool, the reality is HR 40 has been at the halls of Congress my entire adult life. Fun fact about me, Philip Mott was my English teacher senior year in high school. He is Coretta Scott King's nephew. And he made a point to register all of us 18-year-olds to vote. And so when I had Coretta Scott King's nephew as my English teacher in high school, registering his English students to vote, HR 40 was making its way through Conyers to Congress, and it's been there and reintroduced every year. I'm not sure if it was HR 40. I think in its initial year it was 1865. And then maybe a couple of years later, it's been HR 40 consistently over that time. Dr. David Johns, Dreesen Heath, David, I think they both are younger than me. I'm going to say that they are both younger than me, but they are starting, I think, to understand a point that lineage reparationists were at when we kind of got into this space. This idea of playing by the rules, the idea of, keeping relationships in a way with Democrats, and our position as saying we don't have an allegiance. It's reparations is a partisan issue. It is not a Democrat or Republican cry. It is an American cry. And we will get to some of that as we go through this process today. Usually my intro or whatever it is I'm talking about is about 15 minutes, but I just wanted to put that on your radar. Dreesen Heath has an organization, and it is a network. So I encourage people to reach out to the network. It's Why We Can't Wait Reparations Network. She works as a human rights researcher and a policy strategist. I would consider myself an advocate, and I'm also a strategist, and I'm also someone who practices human rights. You won't hear me using terms like tether. I think that's dehumanizing. If I don't want somebody calling me the N-word, I'm not going to be calling someone else a tether, whether or not I agree with their political positions. I do think that there's something to be said about the love language that Malcolm X and Dr. Martin Luther King used when they spoke to each other, even when in disagreement. This modern era of who we are, we disagree, and it's like, damn you to hell forever, and I'm not going to work with you. But two brains generally are better than one, because people think differently, people analyze information differently. We all have our individual human experiences from which to draw on, and there is a need within this reparation space to have communion, community, exchange of ideas, even if we don't agree on things that, again, are not new and have been here since Delaney and Frederick Douglass when it was the Go Back to Africa, which we're going to get into today, or stay here in the United States and fight. I'm going to stay here in the United States and fight. If I get some land, I would prefer it to be in the Carolinas, which is where on my maternal and paternal side, that's where my people are from. But I did want to share that video. And again, you should follow Dr. David Johns and Dreesen Heath. If you're not, I think she still has me blocked. I don't know. But yeah, what she said, what they said. In any event, we're gonna get right into it. First of all, a lot of people think the conversation with Trump was about citizenship rights. Newsflash, it's not. You can look this up, la.cornell.edu/constitution yourself. It has, reading the Constitution as an adult is a very different experience than civics in like the 5th grade. You learn a lot. And I want to get into Article 1, which is legislative powers, but specifically I want to get into Section 8. So Article 1 is our legislative branch, meaning the House of Representatives shall be composed of members chosen every second year by the people of several states, and the electors in each state shall have qualifications for electors, blah, 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 blah. The requirement in order to be in Congress, including the Senate, Congress are the same house ultimately, but they should have attained an age of 25 years and be 7 years a citizen of the United States. I want to hold you all to that, because I want you to understand as adults how quickly someone who is naturalized in this country can immediately head over to be in Congress. They only need to be naturalized for 7 years. I don't know how many people knew that, but we do things the reparations way, which means I'm giving you a reparations perspective. I want you all, as you analyze things, as you see things, I want you to see it through a reparations lens, because that is why I created this show. Okay, so we're going to go back. I want people to understand congressional powers, right? They are the legislative branch. It is vested with them. When we go to Section 8, it kind of gets into all the things that they can do, right? So Section 8, Congress shall have the power to lay and collect taxes, duties, imposts, excise, pay the debts, and provide for the common defense, which is why we have a crazy war budget that's vastly larger than the general welfare of the United States, which would mean us, the people. but all duties, imposts, and excises shall be uniform throughout the United States, meaning they can't be charging folks down in Texas one rate of tax and then Californians another thing. Everything has to be uniform. They can borrow money, regulate commerce with foreign nations and among several other states, including Indian tribes. They are alone able to establish a uniform rule of naturalization and uniform laws around bankruptcies throughout the United States. They alone can coin and regulate monies, okay? Fixed weights and measures, meaning how we measure gold and so on and so forth, whether we're using inches or liters. Anyway, Congress has the power to do that. They can basically provide punishment for counterfeiting. Tribunals, they can create tribunals and courts inferior to the Supreme Court, okay? They can define piracies on the seas, felonies committed at sea, offenses for nations. They only can declare war and grant letters of reprisal and make rules concerning the capture of land and water, because back in the day, that's how wars were fought. Land, water, things are a little, from the sky now. But in any event, basically, they can provide organized arming, disciplining of the military, so on and so forth. And the most fun fact, let me find it. Basically, they can also make any law which makes it necessary and proper for them to carry out the execution of their powers. Meaning, if they want to create departments, they can. If they want to create agencies, they can. If you look on the United States government website, I feel like it's over 100 different agencies. I don't know if you all remember when that letter went out from the conservatives. If you remember when the letter went out from the conservatives, they sent it to all of the federal agencies in addition to Fortune 500 companies, okay? And so the people who create all of those agencies basically come from the powers that sit with Congress, okay? They legislate, meaning they write the laws, the statutes. Federal government is governed by, they are the people who write the laws, including naturalization. Hold on to that for a minute. I almost feel like we're not going to even be able to get through all of this today, but I'm going to do my best to try. Okay. And then the third thing that I want you all to see is the power invested in the judiciary. And what we saw the Supreme Court do was basically what the Constitution says that they can do. The judicial power of the United States, that means the judging power of the United States, is vested in one Supreme Court and in inferior courts as Congress may deem. And so those are all the different district courts around the United States, okay? The judicial power shall extend to all cases in law and equity arising under the Constitution. I just told you all who gets to do naturalization law. So this matter is a matter of constitutional law. And not only is it a matter of constitutional law regarding naturalization, it is constitutional law because we have a president that is doing a thing, and we have Congress who is empowered to do a thing. And so the question that I'm going to present to you, because it's a case that actually happened, is we want to focus on the citizenship aspect. But the way I see it, this case is about presidential power versus congressional power. You're not going to hear too many people say that, but that's how I see it. Does the president have the power to issue the executive order that he did issue? Okay. Thank you, Cornell, for that quick and handy constitutional guide. I want to give some backdrop into naturalization laws. And this website, and this is the congressional website, gives a quick breakdown. Article 1, Section 8, Clause 4, that is the law, early naturalization law. Congress established its first uniform rule of naturalization through the Naturalization Act of 1790. Okay, The act provided that free white persons who resided within the limits and under the jurisdiction of the United States for at least 2 years could be granted citizenship if he or she showed good character and swore allegiance to the Constitution. When you read that 200-page opinion on this case, you are going to hear things about allegiance. Do children pledge allegiance? Whose allegiance when they're born? If the fact that they're born here, they're going to pledge their allegiance to the United States. Now, I don't know how much time the Supreme Court justices sit on TikTok or YouTube and listen to the conversations of how other people, non-citizens, view the United States. Why they come here, it's a cash cow. We've seen hundreds of billions of dollars get sent out of the United States, supporting families all around the world, whether it's India, whether it's down in Mexico or South America, whether it's China. We see that a lot of money goes from the United States, from migrants to home nations, wherever they may be. So I just want you guys to remember this allegiance because it's going to come up in the word. In 1795, Congress amended the naturalization law by requiring an applicant to submit a declaration of intent to become a citizen at least 3 years before naturalization. Eventually, they extended it to 5 years, and then in 1798, Congress passed the Alien and Sedition Acts, which, among other things, lengthened the period in which someone could declare their intent to become a citizen to 5 years, okay? And then in 1802, that was repealed, and then it was set back. So at the end of the day, I just want to point out that this is a congressional power. Naturalization, how people are naturalized, is a congressional power, although, and I will get into the 14th Amendment, but it's going to be in the presentation that I showed you. Bill of Rights are basically amendments 1, I think, to 10. I think that's right. And then the 14th Amendment, right, due process, I'm going to just read real quick. All persons born or naturalized in the United States and subject to the jurisdiction thereof. That comes up in the 200-page opinion. What is the jurisdiction thereof? How and when are newborns and people and naturalized citizens subject to the jurisdiction of the United States? But anyway, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Where people reside came up in this case. Why? Because this is a constitutional case. That's why it wound up at the Supreme Court, okay? And then the piece of the 14th Amendment that is part of the Reconstruction Bills, 13th Amendment ending slavery, 14th Amendment making Negroes citizens of the United States, and then the 15th Amendment giving us the right to vote. Those are the Reconstruction 1866 laws, okay? And we got to remember during the 1866, what is the other thing that happened? The other thing that happened was President Johnson rescinded Field Order 15, taking land and self-governance away from American freedmen. And that is important, as whenever we talk about immigration, why people don't understand why we as American freedmen have different experiences, because we don't have the immigrant experience. Our American story is different, and it's important to understand these differences when we're analyzing judgments that come down from the Supreme Court. And today, this equal protections, nor shall any state, meaning any of the contingent United States, 50 United States, shall deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the law. This law was made to protect us. It is now being used by a Department of Justice Assistant Attorney General Hermit Dillon to do just that, to repeal reparations from Asheville. Now she's working on Evanston. this is where we are. So when people talk about, oh, this is long-standing, and long-standing, what is also long-standing in the United States of America is the fact that redress, reparations was not granted when enslaved people were alive. It hasn't been granted to their descendants. It hasn't been granted to the survivors, and they are survivors, just like they are Holocaust survivors. They are Jim Crow survivors. It has not been granted to Jim Crow survivors in these United States of America. All right. So I want to share, I shared that before we get into President Trump, I want to share just pieces. This is from the 1890 Congressional Record. Back in the 1800s, it's not like it is now where everything was archived and you could just sort of drill down. Basically, every day, whatever happened in Congress was recorded. It was put into one of these books. This is from June 26, 1890, and this number 6536 is the reference. The next page, 6537. These are the old records from the 1800s in Congress. On June 26, 1890, there was a discussion about elections. There was a discussion about Congress and what was Congress's responsibility for basically protecting Black folks at the polls and ensuring that everyone who wanted to vote was able to vote. Did Congress have a need to be sending essentially agents to make sure at the state level this voting could happen? But voting and the administration of voting is a state right that's also in the Constitution, and that was part of this debate. But I'm always doing research. I don't necessarily consider myself a historian, but I'm always doing research, and in doing research, I kind of stumbled upon this little gem, and as if the universe wanted me to pay attention, these particular sections were marked. And let me see if I can make this a little bigger for y'all to read along. I'm trying to get it all in the margins. All right, that's as big as I think we should get it. I'm going to read just a couple of sections here. The wrong of slavery was expiated by the North, which condoned it as much as the South, which upheld it. One thing is certain, calling each other hard names still, one thing is for certain, we shall never deal with it successfully by wrangling over it and calling each other hard names. I think this is still true today. White folks, I don't care what y'all think about us. Black folks, stop putting your emotional heart on your sleeve. This is ultimately going to wind up being some sort of legal fight. I already told you it's a spiritual fight, but the calling of hard names, people in their feelings, my family didn't get here until, none of that matters. It doesn't matter because American freedmen are the only Negroes that were written into this Constitution. We were the only ones freed by the Emancipation Proclamation. We were the only ones after this Emancipation Proclamation and the decimation of the civil rights and political strides made, who had a president, President Johnson, negate all of our strides. With that compromise of 1877, we are the only people who had enslaved people alive and had this Congress not appropriate funds to them. We are the only people who then were subject to an additional 100 years of subjugation through segregation law, Jim Crow laws. We had convict leasing, all of these things up until 1968 in the United States of America. So my immigrant folks who were so vested in this particular law that Trump wrote, his executive order, I need you to understand that your American story is not the American freedman story. In any event, I will continue on. The Negroes in the United States did not come here by any will or action of their own. They did not seek to force themselves upon us as the Chinese, whom we have excluded, tried to do. They were brought here by force under circumstances of hideous cruelty. They were held in bondage and ignorance. They were sold on the block and they quivered under the lash. It is idle to say that they are better off than they would have been if they had stayed in their native wilderness. And we hear that argument. Oh, you're better off because you came to America. I agree again with this author. It is idle to say that they are better off than they would have been had they been allowed to stay in their native land. Better an eternity of freedom, he says savage freedom, miss me with that, than the civilization which came to them with the hammer of the auctioneer in one hand and the slave driver's whip in the other. Which means this author understood what freedom is. Your own will, your own spirit, your own way of living. No material comfort is worth having which is purchased by such suffering as theirs and by more than 200 years of slavery. At last, a time came when there was war in the states to decide whether this government should survive or whether the country should be torn into two conflicting parts, and on the outcome of that war, the fate of race turned. What did this race do in the mighty struggle? When it began, the Negroes were not citizens. They were only slaves, although in the catalog of the Constitution, perhaps they passed for men. They didn't even think we were men. This is how they were addressing us in Congress in 1890. To the government on one side, they owed no allegiance, for its power had been used, so far as they knew, only to rivet their bonds, to seize them by the throat and thrust them back into bondage. What is he talking about? Jim Crow laws. This goes on. I can't, we're down to almost about 30 minutes, but, I have to read it. What then did they do? This race that owned nothing to either combatant but the single debt of a great revenge. On one side, they took their muskets in their hands and went to the front by regiments, us. They died in the trenches, us. And on the battlefield by hundreds for the government, which up to that time had only fastened their chains more securely upon them. On the other side, they remained on the plantations. That's us too, those of us that stayed behind. They cared for the defenseless families and for the property of the men who had gone away with an army whose victory meant the continuance of slavery. So we protected the Confederates too, and they know that. Yet the annals of the world tell no story of San Domingo massacre or the slaughter of the helpless beings who stayed at home while nearly every able-bodied white man was bearing arms on the field. They gave loyalty to the government, again us, which had spurned them, and fidelity to men who had held them in fetters, which means we remained loyal even to the Confederates who were going to fight. We were loyal to this country and have been. Such loyalty and fidelity as this demands some better reward from the people of this country, both North and South, than the Negro has ever received. He's saying we deserve it. What he needs is neither brutality on one hand nor sentimentality on the other. He should not be petted and coddled because he is a Negro American, nor should he be intimidated and cast out for the same reason. We are altogether too fond of prefixing qualifying adjectives to the word American. If a man is not satisfied to be an American pure and simple and to abandon the prefixes which denote race and distinction, then he is better outside this country than in it. Truth is susceptible to wide application. I would now apply the men of the colored race. We have clothed them with the attributes of American citizenship. We have put in their hands the emblem of American sovereignty, whether wisely or unwisely done is no consequence now. It has been done and it's irrevocable. We owe them no more, no less. So they're saying, we freed y'all, gave y'all citizenship. We owe you nothing more, right? Nothing more than any other American citizen, rich, poor, white, or black. The government which made the black man a citizen of the United States is bound to protect him in his rights as a citizen of the United States, and it is a cowardly government if it does not do it. No people can afford to write anything into their constitution and not sustain it. A failure to do what is right brings its own punishment to nations as to men. There is no escape from the inexorable law of compensation. As Lincoln said in his second inaugural, we still haven't been compensated. This was written in 1890. 1990 was 100 years ago. We're at 2025. So that's 35 years. 135 years later, we still have not been compensated in a meaningful way. If we fail as a people to deal with this question rightly, we shall pay for it just as we paid the debt of slavery, of which all this is part. What then ought we do? After the war, when this great body of slaves was cast helplessly into freedom with all the responsibility of citizenship suddenly forced upon them, I believe that it was wholly within the power of the white race to so conciliate and divide them that the Negro as a sectional political question should never more have been heard of. Perhaps it was asking too much of human nature to expect this to be done. Basically, the white folks couldn't stop being racist. At all events, it was not undone. It was declared that the problem could be solved by methods other than by the law. Those methods have been tried and they are failure. For 15 years, they have prevailed completely, yet the South comes to Congress with the demand that measures should be taken to deport the Negro population. That the proposition is impractical does not deprive it from its significance. So I just wanted to read this to you all, because in this idea of constitution citizenship, we always think, and the back to Africa, Pan-African Negroes that want to go back, the white folks been trying to ship our black behinds back to Africa since 1890. Okay, you got to know your history. And the part of this I want to get into before I get into my presentation, because I want to make sure, oh no, it's not that. I want to make sure we have enough time. You know, this is what went to the Constitution in 1899. What went to the Constitution in 1899 was Vaughn's plea for the help of old slaves. And Vaughn basically said, this was prepared by W.R. Vaughn of Omaha and introduced by the Honorable William J. Connell from 1st Nebraska District by request. Section 1. All persons released from involuntary servitude, commonly called slaves, in pursuance of the proclamation of ex-President Abraham Lincoln, dated respectively September 22nd, 1862 and January 1st, 1863, and in pursuance of amendments to the constitutions of several states wherein slavery or involuntary servitude formerly existed, recognized by the federal Constitution and laws of the United States, or by any law, proclamation, decree, or device whereby persons once held as slaves or involuntary subjects in consequence of race or color or federal or state recognition of involuntary servitude, except for the commission of a crime, wherefore the party shall been duly convicted, shall be hereby made a pensioner upon the bounty of the United States. Okay? What they were seeking basically was any person who may have been held as a slave, again, not party to a crime, who shall have been released such servitude and reached the age of 70 years old. So you 70, you done lived your whole life as a slave, and here you are, you free, shall be entitled to receive the sum of $500 from the Treasury of the United States, hereby authorized to be paid out of any monies not otherwise appropriated, and the sum of $15 per month during the remainder of their natural lives. Okay? This provision shall apply to male and females alike, so they're going to get paid equally. And persons released from servitude by the age of 70 years, and who are 60 and over, so I guess the next tier down, shall be entitled to receive the sum of $300 and also $12 per month until they shall reach the age of 70 years. So basically giving elderly folks a step up, and then if they were 50 years old, they would receive $100 and $8 a month, right? And then when they hit 60 years old, they would receive the $12 a month. So this is what the cost could have been back in 1899. And this bill went to Congress multiple times. I think the last time it was introduced was something like 1920-ish, somewhere around there, maybe 1933, somewhere in there. Early 1900s is the last time this bill was attempted to be introduced. And what I also want to point out is in here, he says, of course, there's disposition to make light of this proposition because it's a vast expense. According to the criticism of public prints, the expense would be less than 33% of the cost to the government as the Civil War itself. So back then, these folks were doing the math. Our ancestors were doing the math and basically said, it's going to cost you 33% of what the Civil War cost you monetarily. And the country at that time was emerging at a rate of $140 million a year, right? Basically saying that the men that control wealthy banking and institutions are howling at the prospect of the early payment of the national debt, right? They're telling us what's going on at the times. It's respectfully suggested that justice to the Negro might prove a panacea for the woes they have in such serious contemplation. What a pity it would be to let a poor millionaire fail of an opportunity to turn an honest penny. That was a cry calling on the millionaires and the businessmen at that time to, again, invest in the Negro, invest in these old people who are 50, 60, and 70 years old. Pay them a pension because they have lived their lives in servitude. And we have people today that want us, Black Americans, to have empathy and feel more for other people, to go to fight for other people when we are still fighting for ourselves for what was due from 1890. We're going to get into this Trump well, I don't want to remove this. We're going to get into this. I'm like talking to the screen here. So we can share this information. Oh, before I do this though, I did want to share I wanted to share Trump's, let's show his thing here. Protecting the meaningful value of American citizenship, okay? By the authority invested in me as the president, by the Constitution and the laws of the United States, I order the privilege of United States citizenship is priceless and a profound gift. The 14th Amendment states all persons born or naturalized in the U.S. and subject to the jurisdiction thereof are citizens. Okay, but the 14th Amendment never interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment was always excluded from birthright citizenship persons who were born into the United States but not subject to the jurisdiction thereof. Consistent with this understanding, Congress has further specified through legislation a person born in the United States subject to the jurisdiction thereof is a national citizen. Okay. Policy 2, it is the policy of the United States that no department or agency in the United States government shall issue documents recognizing U.S. citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize U.S. citizens to persons that, one, when their mother was unlawfully present in the United States and the person's father was not in the United States or was not a U.S. citizen or lawful permanent resident at the time of the child's birth, or two, when that person's mother's presence in the U.S. was lawful but temporary. The person's father was not a U.S. citizen or lawful permanent resident at the time of said person's birth. So those are the two classes of people basically that President Trump wanted to go after: people who were either here unlawfully and folks who were here temporarily, even if lawfully. So those were the two categories, and I just wanted to state that as we jump into this. And this is the presentation. I have 20 minutes, so I'm going to try and be quick. The case that came to the Supreme Court was Trump versus Barbara. This was birthright citizenship and the 14th Amendment Citizenship Clause. It was argued April 1st, 2026, and a final decision was rendered just this week, June 30th of 2026. I wanted to give you guys an IRAC, which is a methodology, legal methodology of breaking down a case. And this is what I came up with after doing all that research. And it's 3 o'clock. It's almost 4 o'clock. I have been up since 8 o'clock researching just to pull all this information together to give to you all today. Okay, so procedurally, what happened on January 20th, 2025, President Trump issues this executive order 14160, denying automatic citizenship to children born in the United States to parents who were here unlawfully or temporarily, right? Those are the two issues from his executive order. The U.S. District Court for the District of New Hampshire is the original trial court where this case was heard. The parents sued on their own behalf and on their children's behalf at the district court and agreed that the order was unlawful. Temporary approved a national group, a class of affected children, and blocked the order from taking effect. So the lower court said, this is not going to fly. This is unconstitutional. Okay. And as a result of that, what should have happened is this should have gone to an appeals court, but this was actually expedited to the Supreme Court because of what I told you in the beginning of this video. This is constitutional law, and constitutional law has to be held and heard by the U.S. Supreme Court, and it has to be heard by the Supreme Court, especially when it is a conflict of powers. Whose power is it? Does the president empower? Does he have constitutional power to write the executive order that he did? Or is it a duty of Congress, the power of Congress? And so that's why the court accepted this. And then ultimately, I'm going to give you the ending, and then we'll walk through it. The district court ruled and agreed. The Supreme Court ruled and agreed with the district court. So at the end of the day, the Supreme Court agreed with the lower court and said, this is all not constitutional, so get your executive order out of here. That's what was said. Okay, the question, are children born in the United States to parents who are here unlawfully or temporarily still subject to the jurisdiction of the United States? Meaning, are they U.S. citizens at birth under this 14th Amendment? Okay. There were significant pieces of legislation and rules and law that was brought into this case. Again, that case is the opinion is 200 pages. It's 197 pages, people. I had to pull this into a form that I could walk through it because there's no way I could read 197 pages of stuff. So this is what we have here. So the 14th Amendment clause, again, is all persons born or naturalized in the U.S. are subject to the jurisdiction thereof and are citizens of the United States and of the state where they reside. This is all born out of English common law. And again, I went back to that 1890 reading where they were talking about voting and basically whether or not to protect the Negroes at the polls because they knew we were being mishandled back in the 1800s and they wanted to validate good voting records. These laws come from Old English law from the 1600s. from the Schooner Exchange with McFadden case from 1812, and from the U.S. versus Wong Kim Ark from the late 1800s, about the turn of the century. We can dip into law to repair people today, but we cannot dip into law or what happened to American freedmen who were enslaved in this country and move the law forward to today for redress. Again, giving you this case from a reparations lens. A child born within a king's territory automatically owed loyalty to the king and was a subject. No matter how brief the parent's presence, only two narrow exceptions: land the king didn't actually control, and children of foreign diplomats. This is a very aristocratic, elitist kind of law about monarchies and kingship. But this is the law of which citizenship was based on in the United States during its formation. In 1812, under Schooner versus McFadden, the Schooner Exchange versus McFadden, Chief Justice Marshall defined jurisdiction as the nation's full and complete power within its own territory, given up only narrowly under circumstances regarding foreign diplomats. Meaning, if you were born here, unless your parents were a foreign diplomat that happened to be here, you're American. That's what was decided in 1812. And then in the Wong Kim Ark case in 1898, the precedent held that the 14th Amendment simply restates the common law birthplace rule, subject only to the diplomatic exception of members who were of sovereign Native American tribes. So in 1898, they accepted Indian folks who had treaties and who were tribal nations, okay? So tribal nations, foreign diplomats, 1600 monarchy law from the UK, British law, that made its way into the founding of the 14th Amendment here in the United States. Okay, analysis, historical point. Presence in the country, even if brief, created a loyalty, or at least that's what they argued in that opinion, producing citizenship with only two narrow exceptions, right? The Indian Territory exceptions and foreign diplomats. Dred Scott is all up and through those opinions. Dred Scott, we got American freedmen. I saw black folks online being all emotional about this, and I'm here to tell you, this case, even though it's a Reconstruction law, it's not about us. It's actually about political powers enumerated powers issued by the Constitution to the president or to Congress. And did the president have the right power, executive power, to write that bill? And the answer was no. Okay. So there was a rejection of sufficient allegiance argument. It was no historical evidence from 1776 to 1868 that ties allegiance to a permanent home or a domicile. That wasn't really found in congressional debates. The text controls not later policy shifts. So government's positions from the 1800s after ratification cannot override the amendment's plain language, right? They're basically saying you can't rewrite this thing, and there's no historical exception that fits. Children of unlawful or temporary present parents are not diplomats or tribal members, and so they don't have a sovereign state of allegiance. Their allegiance is deemed to be that with the United States of America. The conclusion is the executive order was unconstitutional under the 14th Amendment. Children born in the United States to parents, whether here unlawfully or temporarily, are basically subject to the jurisdiction of the United States. In terms of the voting, we had the majority opinion was written by Roberts. I read it. It was long, to say the least. It had a lot of law and reference and, historical context and the UK stuff. I was surprised to see that something from the 1600s was still standing up in an opinion by the Supreme Court today. I mean, it's one thing to be a young nation in the 1800s. It's a different thing to be here for 250 years and you're still going back to British law to stand up your law as a nation. I thought that was interesting. Sotomayor joined in with Ketanji Brown Jackson. They agreed with that decision, as did Kagan Barrett. Kavanaugh agreed with the decision, but he disagreed with the statutory grounds. And I actually agree with Kavanaugh, and I have one more slide to show what his position was. Thomas, Gorsuch, and Alito were all no's. Everyone was talking about Thomas and Freedman this and Freedman that. I need you all to understand something. The conservatives, the Heritage Foundation, the people who were talking about God, what was that? The folks that were talking about, the 14th Amendment. That's what we're talking about here. The people talking about the 14th Amendment and who had sent out those letters. I need y'all to remember something. These are the people that ultimately want to get rid of the 14th Amendment. So if Trump had been successful, the next move by those Heritage Foundation 2025 people, they would have been trying to figure out how to make us Negroes somehow not American. I don't know that they would have been successful at that, but they tell, like, if you follow them, that's the kind of weird stuff that they're talking about now. For me, let's get to Kavanaugh real quick, and then I'll give my 2 cents as we close out the show. But Justice Kavanaugh, he agreed with the executive order and that it should fall, but not because it violated the Constitution. He reached the same result basically through a narrow statute path. He disagreed with the constitutional holding. The executive order does not violate the 14th Amendment. In his view, he did not accept that the Citizenship Clause alone guaranteed birthright citizenship. He found it unlawful on statutory grounds instead. The order does not contravene a federal statute. The provision is long interpreted to adopt Wong Kim Ark's birthright citizenship rule, and he leaves the door open for Congress. Congress could, consistent with the view, with his being the president's view of the 14th Amendment, pass new legislation creating exceptions. It just had not done it. The Congress hasn't done a lot when it comes to naturalization, which is why we have a president trying to take control of the reins. But he questioned applying the 1898 framework today. Modern immigration categories were unknown during the 14th Amendment for the framers of the Constitution. And Kavanaugh cautioned against assuming that the clause automatically resolved them, meaning you can't just speak for them wholly because these terms and situations did not exist at the time. So this is kind of how I see things playing out. I think that Trump gave 2 very narrow pathways. I think that this could go a couple of ways. There could be, agencies are under the president's executive power. So immigration, naturalization services fall under presidential executive power. The president could basically go to the heads of those departments and those agencies and say, look, if we have women who are coming here and having children and then leaving very soon with their children, I don't know how many of you know, but U.S. Child passports last for only 5 years. People who can afford to come here to just have a baby can certainly afford to come here 5 years later and re-up on their child's passport. But the controlling of ports and this, that, and the other, the agencies determine who can come through the ports. And so Congress can set new law. The president can get to talking to the agencies to maybe come up with some new rules that say, if you left when your child was born and you coming back just days, months before the kid's passport expires, they don't have to let people into this country. And so I think that there's an opportunity, again, like Kavanaugh said, I think that Congress is empowered to legislate. And I think Congress can, for us, what I want to see us American freedmen people not have our hearts on our freaking sleeves. I did see some people who were like, oh, they're giving us new strategy and new ways to work based on the language they used in the opinion. I also agree with that. That's how I kind of wound up down the rabbit hole a little bit, and wanting to understand like citizenship with us. What was that looking like in congressional arguments back in the 1800s? And I found some language in terms of how people viewed us, and they still view us today like that. This government has not been consistent with American freedmen. It has not been consistent in our redress. We are not going anywhere. The claims are not going anywhere. What was interesting in that 1890 congressional discussion about voting and whether or not Congress should be protecting the Negro, what was interesting to me is that they were like, yo, if we don't get this right, the country will fall. I believe that. I don't believe a pendulum swings one way. At some point, we live in a world that's a dual. The magnets are opposing and attracting. We live in a duality. At some point, the pendulum has to swing. And I think that the American freedmen people have been very gracious to America's government. We've been gracious to all the administrations, the presidents. We've tried to be participants in this society. We have been set upon by Nixon, by his war on drugs, which really ravaged our people. And this is after the killing of Malcolm X and Dr. Martin Luther King and Medgar Evers and people who were trying to make change to the point where we didn't even want to be politically active. And you saw it. We weren't as a people in the United States after the killing of those very, very influential, powerful men. And we were stagnated. And now we have a generation that survived the crack cocaine epidemic. We survived the HIV epidemic. We survived COVID. And our focus is on these reparations. HR 40 has been at Congress for 35 years. If Congress wanted to move it, it would have been moved. If the president wanted to move it, and word on the street is Biden was willing to move it, and then some legacy reparations organizers talked him out of it because they wanted it to move through Congress. They thought they had whipped enough votes. I don't understand stupid stuff like that. I understand that politics is fickle. I understand that when you have an opportunity, you seize it, just like in California, the Congressional Black Legislative Caucus. I don't understand how you have a senator who has written 3 bills supported by the people, and then none of you have the spine to bring it for a vote. The only reason that happens is there are backhanded deals with your Democratic Party promising you that you could be the next. I would encourage you all to look at Letitia James. I don't think whatever was promised to her is materializing in the way that it was told to her. People, stop selling your souls. Stop waiting for an institution and a government that has really, really just been non-responsive to our needs. We are the people who should be doing a modern day Tea Party. We have been paying our taxes since 1776. Or I should say since 1865, since we were freed. We've been paying our taxes, and we have not had equal protections under the law. Full stop. It's everywhere in this country. And so buckle down on your boycotts. Continue looking for Black businesses in your area. Try to do business with each other as best you can until we accumulate enough funding to play this political game the right way. That's how I'm going to end this because I don't have any more time. But this is Friday Jones, uncensored, giving you a pop-up and my interpretation of what that case was about, which really had nothing per se to do with American freedmen. It was about who had that constitutional power, President Trump or the Congress. Until next time, I'll see you next week, Friday. Don't know what I'm talking about, but we'll find out together. Happy Friday, y'all.